All right, we're getting there. Here we go. All right. So once again, I am glad to share this time with you as together we explore racism in America, the history we didn't learn in school. Today, we're focusing on part 5, voter suppression then and now. As we've traced the chronological history of our country from its founding through the Civil War, and through the civil rights movement of the mid-20th century, we have seen repeated examples of concerted efforts to suppress the voting power of non-white people. Today, we're going to focus explicitly on the right to vote as a foundation of our democracy and the extraordinary efforts that have been expended and are intensifying to this day to prevent these citizens from achieving meaningful representation. Just a quick recap from last week, where we looked at America's criminal justice system, specifically the key events of the war on drugs, beginning with President Nixon in 1971, President Reagan in 1982 and 86, and President Clinton in 1994. We saw how law enforcement incentives have led to the militarization of our police forces. And I'm very sorry about that spelling error. I can't tell you the number of times I've looked at this chart and never seen that. Okay. And so what we came to understand is that in terms of mass incarceration, the United States leads the world. 5% of the world's population and 25% of the world's inmates. And these changes and these laws and these initiatives have had a disproportionate impact on people of color, such that our criminal justice system is racialized at every stage. And we have also seen enormous numbers of instances of individual police violence. So heading forward to the issue of voting, we're going to look tonight at the historical framework of voting rights in the United States, the path to representation for African Americans following the Civil War, and then what we've come to see is the inevitable backlash, the adaptive tactics of the white majority that have continued for nearly 100 years. We'll look at the transformative Voting Rights Act of 1965 and the consequences of the Supreme Court decision in Shelby County v. Holder in 2013, and specifically the various phases of the ongoing assault attempting to prevent certain of our population from being able to exercise their right to vote. So in the context of our founding documents, our historical framework, we begin with the Declaration of Independence, where Thomas Jefferson wrote, quote, "Governments are instituted among men." I think he meant women too, but anyway, governments are instituted among men, deriving their just powers from the consent of the governed. So it is the consent of the governed that delivers the authority, the power to govern. And of course, the consent of the governed in the United States comes about by the right to vote. Interestingly, in the United States Constitution, there is only one clause that refers to voting. It is Article 1, Section 4, Clause 1, and it reads, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But Congress may at any time make or alter such regulations, except as to the place of choosing senators." That's all the Constitution has to say about voting. But there are any number of constitutional amendments that have been ratified and made part of the Constitution. In fact, once you get past the Bill of Rights, which are the first 10 amendments to the Constitution, almost a third of the remaining constitutional amendments have something to do with voting. The first, the 14th Amendment, as we know, was passed during the period of Reconstruction following the Civil War, where it granted citizenship and due process to those who had formerly been enslaved. The 15th Amendment in 1870 said that the right to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. That amendment was enacted because the 14th Amendment was not being followed by the states. And so the 15th Amendment was explicit that it didn't apply to the broad aspects of citizenship as the 14th Amendment did, but specifically to voting. The 19th Amendment was ratified in 1920, giving women the right to vote. Barely 100 years. Imagine what the country was like. Never mind. The 23rd Amendment gave residents of the District of Columbia the right to vote for president and vice president. As we know, DC does not have a congressperson or a senator, and until 1961, the residents of the District of Columbia couldn't vote in any national elections until the 23rd Amendment said that they could indeed vote for president and vice president. The 24th Amendment was ratified in 1964, and it was yet another example of a constitutional amendment being required to enforce something that had already been legislated and made legal, and that was to outlaw poll taxes. Poll taxes had been outlawed by law years before, but the states continued to ignore it. And so the 24th Amendment, during that height of the civil rights movement, outlawed poll taxes. And then the last of the voting-related constitutional amendments was the 26th Amendment, ratified in 1971, which changed the voting age across the country to 18. That was enacted during the time of the Vietnam War, when the draft was in effect. And so young men as young as 18 were being drafted into the military and sent to fight for their country. And the rationale being, if you could be conscripted into the military and sent to fight, you should have the right to vote for the people who might make the decision to do that. An interesting and little known piece of legislation that has to do with voting is the Snyder Act of 1924. That was the year that Congress passed a law that granted citizenship to Native Americans and gave them the right to vote, similar to the 14th Amendment dealing with African Americans following the Civil War. So it wasn't until 1924 that the descendants of the people who were here first were declared to be citizens of the United States. But that was a federal law that didn't always have the greatest impact on actions taken by the states. And so the last of the laws prohibiting Native Americans from voting was finally overturned in 1957. So up until that period of time, Native Americans could not be guaranteed the right to vote. A really significant piece of our historical framework is the Voting Rights Act of 1965, and we will talk about that a great deal more in just a little bit. But it was enacted to enforce the 15th Amendment that said the right to vote could not be denied based on race, color, or condition of previous servitude. And what Congress came to see was that that amendment was being violated repeatedly in states and other jurisdictions across the country. And so Congress enacted the Voting Rights Act of 1965. And we will talk more. So going back to the path to enfranchisement of African Americans in our country, we know that in 1865, the 13th Amendment was passed that abolished slavery, except in the condition, circumstance of conviction of a crime. In 1868, citizenship and due process were accorded to African Americans. In 1870, the right to vote. And that meant representation at last. The Black voter turnout that first year was nearly 90%. If you look at statistics today of voting rights of Americans, they hover somewhere around 50 to 55%. The Black population that was enfranchised as a result of the 14th and 15th Amendment, those individuals voted in enormous numbers. We know that first year they elected 600 Black state legislators, 18 Black state executives. The governor of Louisiana was a Black man. The last time that would happen until 1960. 18 U.S. congressmen and two U.S. senators elected that year were African American as well. And they worked in concert with their white counterparts in all of these legislative bodies to craft laws on finance, on charitable institutions, on penal institutions, on public schools. We talked about it being a ray of hope for a more perfect union following the Civil War. But we know the adaptive tactics began then, and that significant violence as voter suppression took hold. In 1865, the Ku Klux Klan was founded, along with other smaller terrorist organizations. In 1867, the Knights of the White Camellia took form. And these were two secret organizations. But as the acceptability of this kind of violence took hold, public organizations of the same ilk were formed. In 1874, the White League, and in 1875, the Red Shirts. And these were organizations that people were proud to acknowledge their membership. And one of the major initiatives they took on was seeking to ensure that Black people were not able to exercise their right to vote. We revisit the graphic that we saw back in week 2 that saw the preponderance, the enormous number of lynchings that took place during Reconstruction while the federal troops were present in the 5 military districts that oversaw the 10 states that had been in rebellion. And we know that out of all of those lynchings, there were 34 documented mass lynchings, the bigger red dots that show up on the map. And we have looked at this list before, and they were carried out, these lynchings were carried out for a range of reasons. But today we focus on a number of these that were specifically designed to terrorize prospective Black voters. In 1868, in Bossier Parish in Louisiana, white mobs terrorized the Black community in widespread attacks leading right up to Election Day, killing at least 162 people for either registering to vote, going to vote, or having voted. In McDuffie County, Georgia, that year, a Black man named Perry Jeffries, his wife, and 4 of their sons were attacked and lynched by white mobs who targeted Mr. Jeffries because he voted. In 1875, in Clinton, Mississippi, armed white mobs attacked the Black community after a political meeting, killing an estimated 50 Black people for daring to assemble in anticipation of asserting their voting rights. And in Hamburg, South Carolina in 1876, in violence leading up to Election Day that affected the whole community, a white mob attacked Black men stationed at the National Guard Armory and killed at least 6. And so, as we know from this period of our history and the enormous energy that was exerted to keep Black people from asserting their rights, this whole issue of voter suppression was an enormous focus. We know that the 1876 election did not result in an immediate victor, that it required a compromise, a decision by a panel of 15 Congresspeople and Supreme Court justices, 8 Republican and 7 Democrats, who voted 8-7 to name Rutherford B. Hayes the President of the United States if he would promise to end Reconstruction. And he did, and they did. And so Reconstruction came to an end. And so the adaptive tactics were epitomized by the state of Mississippi beginning in 1890 when they held a constitutional convention that was built on a roadmap that had been given them by the Supreme Court, because the Supreme Court had issued a decision that said, this is unconstitutional, this is not. And so Mississippi took hold of the things that the Supreme Court said were allowable. And in forming their state constitution, it required that in order to register, potential voters had to be Mississippi residents for 2 years. They had to pay an annual poll tax, but they were required to pay that poll tax back to the date they turned 21. And so few people had the ability to pay this year's poll tax, let alone all of those that would have accrued back to their 21st birthday. The literacy test that was created, requiring an applicant to read and interpret a section of the state constitution, was chosen by a local official who was always white. And the local official could pick one text. It was typically a short sentence that was given to a white prospective voter to read. But this constitutional convention specifically inserted into the Constitution 7 determinatively incomprehensible clauses that had to be read by the prospective voter and interpreted, but there was no legitimate interpretation because the clause didn't mean anything. And remember, when African Americans were stricken from the voter rolls, that meant that they would be stricken from the jury rolls as well, and so would not be able to participate in forming a jury of one's peers. As we know, James Vardaman, who was the framer of this effort, was quoted as saying, "There is no use to equivocate or lie about the matter. Mississippi's Constitutional Convention of 1890 was held for no other purpose than to eliminate the N-word from politics. Let the world know it just as it is." And so every single Southern state followed suit. Also included in the Mississippi plan was a grandfather clause. And it said, this is 1890, it said that if your grandfather was eligible to vote prior to 1867, then you are eligible to vote. And you don't have to pay the poll tax, and you don't have to pass the literacy test. But if your grandfather couldn't vote in before 1867, then all of these other terms apply to you. Talked about the poll tax and the literacy test. The impact on registration was enormous. And one of the things that I didn't discover until just a few weeks ago is that one of the things that was written into the Mississippi Constitution was a requirement that anyone running for a statewide office was required to get a majority of the votes in every district in the state. Now, the districts tend to be gerrymandered, or they tend to be geographically aligned around racial residency. And in order to be elected to a statewide office, you have to win the majority of the votes in every single district, black or white. And as a consequence, there had never been a black candidate elected to a statewide office in Mississippi. And that only came to an end as a result of a lawsuit filed in 2020. And so it no longer holds, but it is certainly contributing to the lack of elected statewide representatives who are black. We know that as a result of the adoption of the Mississippi Plan, that the black registration rate of 90% dropped to under 6% 2 years later. And of course, Louisiana followed suit with its own constitutional convention in 1898 to establish the supremacy of the white race. And after it was adopted, the number of registered black voters in Louisiana dropped from more than 130,000 to 5,000 and to 1,300 by 1904. And as a result of every state in the South following this roadmap, by 1910, no Southern blacks could vote. And given some legislative action, some appeals to state and federal Supreme Courts, there were some modifications in some of these laws, but by 1940, the voting rate for Black citizens in Southern states had risen only to 3%. One of the tactics that was utilized as efforts began to try to enable more Black people to be able to register and to vote, more were becoming candidates to cast votes. The states began to establish something called a white primary. And that was in order to keep African Americans out of the political process. The Democratic Party in many states adopted a rule that said that Black people could not be members of the Democratic Party. And then they closed the primaries to everybody but registered Democrats. Given the power of the Democratic Party in the Southern states, whoever was elected in the primary was the de facto person elected once election day occurred. So a suit was filed and a case decided by the Supreme Court called Newberry v. United States, where the NAACP and others sued to allow Black people to become members of the Democratic Party. The Supreme Court ruled that political parties were private organizations and not part of the government election apparatus. And so the Democratic Party, as a private party, could exclude whoever it wanted, even though that was the source of the candidates and those who were elected. Ultimately, in Smith v. Allwright in 1944, the Supreme Court finally struck down the white primary as a violation of the 15th Amendment's prohibition against voting discrimination based on race. And so the Texas Democrats established a private association from which African Americans were excluded. And the members of that association held pre-primary elections that selected the candidates for the Democratic primaries. And so the pre-primaries remained in effect until 1953. Even though we know there was more significant amounts of violence directed against prospective African American voters during Reconstruction and the period immediately following, intimidation continued, just not quite as overtly violent as it had been before. But here is an editorial cartoon from the Miami Herald in 1940, just reiterating a point that perhaps voting wasn't the safest, smartest thing for a Black person to do. In addition to specific forms of intimidation, states took action on sharecropper evictions. Now, one of the things that we know is following the Civil War, the institution of slavery, the agricultural economic state, was replaced by sharecropping. And because the Black workers didn't own any property of their own, but rented from landlords, and because so many African Americans were part of this system, if you were evicted from your sharecropper land, you typically had nowhere to go because your relatives were sharecroppers as well. And so the states began using evictions as a means of discouraging Black people from voting. In 1960, that's not very long ago, 1,400 African Americans registered to vote in Fayette County, Tennessee, and about 700 of them were evicted from their homes. White landowners in Greene County, Alabama, evicted at least 75 Black families in 1960, and more than 40 Black families were evicted in Lowndes County, Alabama, just before Christmas in 1965. These evictions were part of a systematic plan to thwart civil rights activism and prevent Black people from voting. Black men and women who registered to vote were required to provide the names of their employers, who could then be notified that their employees were attempting to vote. Newspapers printed the names of Black people who attempted to register, and white citizens' councils distributed voter lists to white merchants, who then denied basic necessities and employment to African Americans who registered or tried to register to vote. This is the 1960s. This is not the 1860s. Many evicted families were forced to live in tent cities that sprang up throughout the South. In communities that most closely resembled refugee camps, entire families sheltered in fabric tents that froze in the winter with no running water and one outhouse for dozens of people. White segregationist night riders terrorized the camps, firing guns into the tent cities in the middle of the night. All this work in resistance to the 15th Amendment and the right of African Americans to vote. And so, as we saw, as we looked 2 weeks ago at the civil rights movement and the heroic actions of so many people, and triggered by the assault on walkers at the Edmund Pettus Bridge, who were walking in support of voting rights, Congress in 1965 enacted the Voting Rights Act, which has been called the most significant piece of civil rights legislation ever enacted in the United States. It was done because Congress had determined that the 15th Amendment was ineffective in ensuring that people, regardless of race, color, or condition of previous servitude, could vote. And so there were 3 key sections of that law. The first, Section 2, basically closely followed the wording of the 15th Amendment. It was, in essence, saying this law is being enacted to substantiate and support the 15th Amendment. That is its authority. Section 4 included a formula to identify jurisdictions that had a history of racial discrimination in voting. These could be states, counties, cities. And the formula said, based on this data, these are clearly jurisdictions that have systematically sought to prevent African Americans from voting. And the law included a provision that Congress could update and rewrite the formula to determine what jurisdictions were covered as time went on, because perhaps some would see the light and stop, perhaps others would think they had escaped and they could start. And so the law provided that that formula for determining the jurisdictions actively seeking to prevent African Americans from voting could be currently identified. And Section 5 said that for those targeted areas, no change could be made to any aspect of voting laws unless that change had received pre-clearance from the Department of Justice. If the Department of Justice said the change was okay, it could be enacted. Otherwise, it could not. The law also provided that it would have to be reauthorized every 5 years, because there were those who said, I don't know that this is such a great idea. And so included in it was, all right, then we'll ask Congress every year to reauthorize the law for another 5 years. And so in 1970, Congress reauthorized it for 5 years. In 1975, Congress updated that formula section and reauthorized the bill for 7 years. When it came up again in 1982, apparently Congress said, you know, we're spending time on this and we don't really need to, so let's reauthorize it for 25 years so that we have to deal with it again for a while. And then when it came up again for reauthorization in 2006, Congress overwhelmingly reauthorized it for another 25 years. The vote was 390 to 33 in the House, and it was unanimous in the Senate. Imagine that for a minute. So here it is in 2006. It's reauthorized for 25 years, but in 2013, a case makes its way to the Supreme Court known as Shelby County v. Holder. Shelby County, Alabama v. Eric Holder, Attorney General of the United States. And the Supreme Court took up the case and it struck down Section 4. It struck down the formula for identifying jurisdictions in violation. That was 9 states plus multiple counties and municipalities. And the rationale given by the Chief Justice was those jurisdictions aren't doing this anymore. And Ruth Bader Ginsburg said something along the lines of, well, they're not doing it because they're not allowed to. But when that section was struck down within 8 hours, Texas immediately instituted a previously blocked voter ID law that did not pass pre-clearance. North Carolina closed its early voting locations from 16 to 1. Alabama closed the DMV offices where you could get a voter ID in 8 of the 10 counties that had Black populations over 75%. So between 1982 and 2006, the Department of Justice had blocked 700 discriminatory voting changes. And now it's Katie bar the door. You can do anything. And so what happened? Well, the actions that were taken in the years since 2013 have been based on the myth of voter fraud. There was a constitutional law scholar at Loyola University, Justin Levitt, who did a study of all of the ballots cast in US elections from 2000 to 2014. I'm fond of thinking he either didn't have any other life or anyway, he looked at 1 billion votes. And in doing the research, determined that there were 36 cases of potential voter fraud, someone attempting to cast a ballot when they were not the person that they were supposed to be. 36 out of a billion. And yet, the onslaught of voter laws, voter ID laws, has been extraordinary. I didn't realize until I started doing this research that until 2006, there was no state in the country that required you to show a government-issued photo ID in order to vote. Nowhere. But all of a sudden, voter IDs, photo IDs became essential to preventing the voter fraud that doesn't exist. So some examples. Alabama issues, the state of Alabama issues a photo ID to everyone who lives in public housing. It's your government photo ID. You may not have a car. You don't have to get a state, you have a state ID because you live in public housing. That ID, however, is not sufficient as an ID to vote. That means, might not be you. That ID doesn't count. Georgia, after the Shelby v. Holder decision, eliminated 12 types of ID that were valid for voting and substituted 6 types of government-issued photo IDs, many of which were harder to get by poorer Americans. In Indiana, they passed a law that you must have a birth certificate in order to get a driver's license or a state ID. That happens in other states as well. But the law was passed for Marion County in Indiana, which is home to 200,000 Black people, that in order to get your birth certificate, you have to have a driver's license or a state ID. In North Carolina, Governor McCrory focused on fraud. The Board of Elections that he charged looking at 4.8 million votes in 2016, they found one that they thought perhaps a voter ID might have prevented. And then the legislature in North Carolina embarked on a project to gather data on the kinds of IDs that Black people are likely to have or not. And then they tailored the list of vote-worthy IDs for the state to those that Black people are not inclined to have. When that action was appealed, the Fourth Circuit ruled that the law was targeted at African Americans, quote, with almost surgical precision. In North Dakota, the Supreme Court of the state ruled that in order for your ID to be valid for voting, it must have a street address. But none of the Native Americans living on reservations, none of those IDs have a street address. They have a box number. And so all of the IDs available to Native Americans in North Dakota do not allow them to vote. And one of my personal favorites is Texas, where a concealed carry permit is sufficient as a voter ID, but a student ID is not. So if you carry a gun, concealed gun in Texas, it's easy to vote. If you're a student, not so much. Other laws that were passed included voter roll purges, where the election board simply went through and purged hundreds of thousands or millions of voters from the rolls, often because they didn't vote in the last election. There is something called the National Voting Registration Act that says that failure to vote is not, in a prior election, is not cause for being removed from the voter registration rolls. But states did it anyway. Georgia, 750,000 voters were purged between 2012 and 2014. Michigan purged almost 500,000 voters in 2016. The cross-check program was interesting. It came about from the state of Kansas. And it was designed to find people who had registered to vote and were trying to vote in 2 different states at the same time, which had to be illegal because you could only be a resident of one or the other. So the cross-check program sought to match first name, last name, and date of birth. And it said, if those matches in two different states, then this is an attempt at voter fraud. So the state of Kansas was one of 28 states that enrolled in the usage of this program. And that first year, they got a list of 240,000 names that were paired between a Kansas resident and a resident of some other state in the country. And they actually hired people to track them down and determine to what extent this voter fraud was occurring. And they found that there were 6 cases where it was the same person registered to vote in 2 states. In 5 of them, the person had moved to Kansas and was voting there. In the other one, the person had moved from Kansas and was moving there. So ultimately, the states did determine that they were spending an awful lot of money, not for much benefit, in attempting to uncover voter fraud and stop the use of the cross-check program. But the illegal roll purges continued. And what that means is when you go to vote and your name isn't on the voter registration rolls, either you get a provisional ballot, someone has to check with a central organization to see if your name should be there. It makes voting so much harder if you get to the polls and your name isn't on the list. In addition, states began taking aim at resources available for minority precincts. They began limiting early voting polling stations in different geographic areas, depending on the racial composition of the residents. In Indiana, counties that had more than 325,000 people only got 1 early voting site unless there was a unanimous agreement by a bipartisan election board. North Carolina eliminated early polling stations so that 4 to 5 hour wait times were the norm. And in Ohio, they decided there would only be 1 polling station per county, regardless of population. But really intriguingly was what happened in Florida in 2000. I don't know how many of you were alive then. Oh, probably most of you. In any case, what the Board of Elections determined as the election of 2000 was approaching was that 16% of registered voters in Florida were Black, up from 10% in 1996, and that was disturbing. And so Florida election officials devised a laptop program that they would give to local election officials to tap into the central database in Tallahassee. So they had purged the rolls. They had taken tens of thousands, hundreds of thousands of people off the voting rolls in Florida. And so if you went to vote and your name wasn't on the list, the election official at your precinct could use the laptop, go right to the database and find out that, yes, indeed, you're registered. Go right ahead and vote. But they only gave those laptops to 1 predominantly Black precinct. And so in all of the others, if you got there to vote and your name wasn't on the rolls, an election worker at your polling place had to make a telephone call to someone in Tallahassee and have them look up the database and see if you were registered to vote. And there was only 1 person in Tallahassee who was taking those calls. In addition, you remember the hanging chads, the archaic punch card system? A disproportionate share of those were in minority precincts. The white counties had the more modern optical scanners and lower rates of uncounted ballots. And so again, starving the minority precincts of resources and the efficacy of the resources was part of the program put in place by the Department of Elections. And it included a pretty significant effort at what were called ballot integrity programs. Republican agents, sometimes aided by local police, would greet Black people as they were coming up to vote and let them know that even innocent technical errors in their registration information, such as a wrong address, could subject them to arrest. At many locations, the prospective voters were actually photographed with the implication that they could be arrested later. We know that there is a just disproportionate number of African Americans who are convicted felons in our country as a result of our criminal justice system. And so felon voting rights also play a significant role in disenfranchising African Americans. There are 2 states in our country, Maine and Vermont, where you never lose your right to vote. They have polling places in prisons, and you can vote while you are incarcerated. 14 states and the District of Columbia, you lose your right to vote while you're incarcerated, but the minute you're released, you are able to vote again. And so it's a pretty clear line of demarcation. You're incarcerated, you can't vote. You're released, you can. But then there are 21 states that you lose your right to vote during incarceration and any term of probation or parole, at the end of which your right to vote is restored, but nobody tells you at that point you can now vote, and you've been some indeterminate period of time where you couldn't vote, but nobody reminds you that that probation or parole is ended and now you can go vote. And then there are 13 states where you lose your right to vote indefinitely. It requires a governor's pardon of your crime in order to be able to vote again. In one state, both houses of the legislature have to pass a bill that names you individually as someone who now has your right to vote restored. Don't think they spend much time on any of those acts. We know that gerrymandering has a huge impact in representation. In a recent Wisconsin state election, Democrats won 52% of the votes, and that translated to 39% of the seats in the legislature. In North Carolina, Republicans got 50% of the vote and 77% of the seats in the legislature. And there are numerous other instances where similar events occur. And then there's the Citizens United decision by the Supreme Court that basically extended the free speech clause of the First Amendment that said that corporations are just like people, and the government can't prohibit them, can't restrict them from donating to candidates. And so it opened the floodgates for independent expenditures for political campaigns by corporations. And so all of this has been going on ever since 2013, but it began to intensify again as a consequence of the 2020 election, where what was added to the individual actions attempting to disenfranchise individuals or groups of individuals were laws that were enacted that are actually attacks on the legitimacy of the entire system. And so immediately after the 2020 election, in 49 states, legislators introduced 440 bills that would restrict voting access. 19 states immediately enacted 34 laws that did that, focused on voting by mail, voter roll purges, enacting criminal charges for aiding a voter. I have a friend who lives in South Carolina. His next door neighbor is disabled. He has driven her to the polls every year since they've lived there. He can't drive her to the polls anymore because she is not a member of his family. That, of course, is also, it's either South Carolina or Georgia that enacted, I think it was Georgia, that said that it's a crime to give water or food to anyone who is standing in line waiting to vote. And so in some of these states, there are actual criminal charges if you drop off a ballot for someone else. If it's not your ballot, that is potentially a crime. And really interestingly, the assaults on early and absentee balloting, Delaware basically took its absentee voting law and in 2020, because of COVID, opened it up to anyone. And it was by declaring that you had a medical condition that prevented you from voting in person. Well, the medical condition was the fear of the spread of COVID. So it didn't really change the law, it just let it apply at the time of COVID. But the Delaware State Constitution does not allow for absentee voting unless you physically are not able to get to the polls. And what's really intriguing is if we look at the full US election in 2020, there were 158.4 million ballots cast, of which 116 million were early or absentee. And of that number, 85 million of those voters are in the 33 states that are proposing limits to early and absentee voting. And so the potential impact on voting levels, at least voting levels as exercised during 2020, are significantly at risk. And so after the 2022 elections, the assault continued to accelerate. Stricter voter ID. It's more difficult now for voters with disabilities. Polling places can be established that don't have ADA access. If you are blind, it used to be in one state, you used to have someone come with you to read the ballot. That's not allowed anymore. You can't have anyone go with you to the polling booth. They've loosened the requirements to educate voters, and so there are states that change polling places. You've gone to the same polling place every year for years. They changed it, but they didn't tell you. They don't have to tell you that they changed it. In some states, you have to have proof of citizenship. A state ID, a driver's license, is insufficient. You have to have your birth certificate, your passport, your proof of citizenship enabled in order to be able to vote. And then the initiatives and the legislations that are seeking to undermine the electoral process, citizen-initiated election audits, organizations being set up to investigate and prosecute voters, civil and criminal penalties for election officials, these new election integrity functions of intimidation in agencies, the removal of professional election officials and putting in place partisan players and enabling partisan election administration. And so it's not just the individual voter, it's the system itself that is under attack. What could help? Automatic voter registration. That is in place in Delaware. If you get a state ID or a driver's license, you are automatically registered to vote unless you opt out. In terms of redistricting of election districts, setting up independent commissions rather than who controls the legislature at any given moment in time. Make Election Day a national holiday so that it is not so difficult for some people to get off work to be able to go vote. What is a more national holiday than Election Day? Enforce the National Voting Rights Act. Don't let states purge voter rolls. And then the For the People and the Freedom to Vote Acts that are designed to eliminate at a federal level the worst of these violations. You may recall from our earlier discussions that the Constitution says that state legislators can make up all these rules, but the Congress at any time can override restrictions that the states impose. And so the For the People and the Freedom to Vote Act, and importantly, the John R. Lewis Voting Rights Act, which is the replacement for the Voting Rights Act of 1965 that restores the formula for covered jurisdictions, that requires pre-clearance, that stops the incredible rate at which enfranchisement is being limited. And so we need to be aware of these initiatives at the federal level, at the state level, be educated about what's happening, speak up, contact our representatives, make our voices heard, because as Thomas Jefferson said, the powers of a government come from the consent of the governed. And the way we do that is through our vote.